America's center of power changed, and with it, the dynamics of the political landscape. The consequences will reverberate locally, in Florida, on Capitol Hill, and on the global stage. Voters demanded change on the issues that mattered most: the economy, immigration, and social issues. Now, News 4 Jax goes beyond the headlines with political analysts who provide unique context and perspective. Experts focused on the issues making headlines. This is Politics and Power.
The clock is tick-tocking on the Supreme Court's latest calendar. There are several things before the nation's highest court that have national and local significance. Let's revisit what's happening with the social media site TikTok. President Trump signed an executive order pausing the TikTok ban. It provided a liability shield to business partners of the popular video app. Word is several buyers are in the market looking at the social media site, and that could change a lot of things that happen, specifically with TikTok. But there are some considerations that affect social media in general, so this is worth following. In another high-profile case, President Trump issued a patently unconstitutional executive order on his first day in office, the goal to abolish birthright citizenship to children of millions of immigrants in the United States. Birthright citizenship is unique, a fundamental right at the heart of our constitutional order. The question becomes, will the nation's highest court uphold that right? Court, will it flex its muscle and remind the president who really calls the shots on matters of legal dispute? Another case before the Supreme Court, Justices. It has to do with First Amendment questions. This one is the Free Speech Coalition versus Paxton. It's a lawsuit challenging a Texas law requiring websites to verify the ages of people seeking adult content such as pornography. The question the court must answer on this case is, does strict scrutiny apply? It's an important but tricky question. And finally on the agenda today, the Justices considering a case dubbed the Moment of Threat Doctrine. It addresses how much time can be taken into consideration when police kill people. The High Court's decision could make it easier or harder to hold police officers accountable for the use of excessive force. This is Politics and Power. I'm Bruce Hamilton, and joining me once again, constitutional law expert Rod Sullivan. Appreciate you being here.
My pleasure.
So let's start with TikTok. Knowing that there may be a buyer on the horizon, let's look at the big picture. What's interesting about the court's decision is what the Supreme Court did not do. First, it did not accept the premise that all regulation of social media requires heightened scrutiny. Court signaled a genuine openness to the notion that new technologies raise difficult questions, and some of the regulation of those new technologies may have only incidental impacts on speech and not be direct regulation of speech itself. Did the court do the right thing in enacting that ban?
I think so. There were two separate arguments in the TikTok case. One argument was that TikTok could use TikTok for propaganda purposes, or the Chinese Communist Party could to influence U.S. public opinion. That is a direct reflection on whether you should censor TikTok based upon the content of its speech. And I think if that was the argument that the United States made, that then what they call strict scrutiny would apply. You'd have to show the narrowly tailored purpose, is a very hard standard to beat. The other argument here was data. The argument was that ByteDance and TikTok collect people's data, and that the federal government has the right, under intermediate scrutiny, to go ahead and restrict a company that's harvesting data. And this is important data too. This is stuff like keystroke loggers. I removed TikTok from my cell phone when I found out they had a keystroke logger, because I do my banking on my phone, and I don't want the Chinese Communist Party to have my password.
Privacy issues.
Yeah, I mean, it's a security question. And they collect biometric data. So if you use facial recognition, TikTok has that facial recognition. So let's say we got into a hot war with China. China could go in with that information and basically deplete your bank accounts overnight to cripple the United States. The Supreme Court basically said that type of control of a social media site deserves intermediate scrutiny. If the government's interest is important and the remedy is tailored, then it's probably going to be okay. And there was not a single dissenting vote on this. It was a 9-0 decision that TikTok could be shut down. So the next question, I guess, is, did President Trump do the right thing in staving off enforcement for 90 days? Did he do the legal thing? I think he did the legal thing. I don't think he did the right thing, though. I mean, this has been percolating through, first of all, India shut down TikTok in 2020. Biden shut down TikTok on government devices in 2022. The entire U.S. Congress, Democrats, Republicans, all voted to shut down TikTok and gave until January 20th to shut it down. And then Trump says, well, we're not going to shut it down. We're going to do a non-enforcement for 90 days. We're going to get for 90 days, we're not going to punish anybody who allows TikTok to be downloaded, the social media sites or anything else. And we're going to let TikTok have that additional 90 days to determine who to sell to. And so he did that. Do I think it's the right decision? I don't think it is the right decision, but I do think it's legal. I think he can do that.
So I want to get back to what Trump did in just a second, but back to the Supreme Court. Does what the Supreme Court did, does it signal that they may be open to finally moving past the broken 70s model of First Amendment corporate speech rights?
I don't really see a fundamental change. I think what they said was there are a bunch of tests out there, basically 3, but there's a strict scrutiny, intermediate scrutiny, and rational basis. And what they said is, when it's content, we're still going to apply strict scrutiny. When it's something other than content, we're going to apply intermediate scrutiny. And when it's not speech, we're going to just do rational basis. I don't think that fundamentally they've changed. I think if a corporation says, I want to speak on this topic, or I want to prevent speech on this topic, that's going to be subject to strict scrutiny. And when a corporation says, well, I want to restrict speech, but I want to do it for some other reason besides the content of the speech, the Supreme Court is going to say, well, that isn't entitled to intermediate scrutiny. You have to have an important reason, and it has to be narrowly tailored. I should say when the government wants to shut down speech.
Yeah.
Private individuals, of course, are not affected by the First Amendment. Channel 4 is not governed by the First Amendment.
Right. And keep this term strict scrutiny in mind, because it's going to apply to another case that we're going to talk about a little later. And also keep in mind there's this artificial intelligence that has now cropped up that there is some scrutiny on, and whether or not this is going to apply to that.
Yes, yeah. Artificial intelligence is a huge topic that's coming on the horizon. If you use ChatGPT or any of these, artificial intelligence programs, you have legal issues that are totally unresolved.
Well, there's this new Chinese-based AI that just cropped up, and there are questions about it.
Yep.
And what kind of litigation is going to pop up?
Well,
it hasn't yet.
Yeah. I mean, they said they used NVIDIA chips to do it. So they're already investigating whether or not there were export violations.
Right.
The real and then the question is, how did they build a large language model for $6 million when others spent billions? Did they steal the technology and import it into their own? I would be surprised if they didn't. I mean, you just can't do it for that cheaply.
Right.
So it's a real question. And for you people out there who use ChatGPT, you need to be concerned about copyright. Because I've actually read the ChatGPT user agreement, and it says you keep the copyright. But that doesn't mean that all of the AI engines mean the same thing. So you might have written the world's greatest poem. You may be the next Walt Whitman, and you may run your stuff through ChatGPT and come out with an even better version of what you write, and then find out that you don't own it.
You don't own it, yeah. So you're opening the door to potential litigation there.
I'd be careful. So I asked a friend of mine who's a Disney lawyer about this, and I asked him that exact question. Am I going to own the copyright? And he says, Rod, that's the $66 million question that nobody's going to answer for you.
Yeah.
I'm not going to put in writing to you that you own the copyright if you put on something through ChatGPT.
Well, we'll find out when some of these things go to court.
Someday, somebody's going to get hurt.
Back to Donald Trump and whether or not he did the right thing, and I'm going to phrase this way. There are some people that say that what Donald Trump did in pausing the ban was self-serving.
Yeah, well, he has friends who are in ByteDance who had spoken to him about the desire to solve this problem. He actually got on the air and said, hey, well, look, without me, there is no TikTok. It completely goes away.
Well, he also said that it helped get him elected.
Yeah, I don't recall that. But I know he did say that this federal government ought to own half of it because we're the ones who are going to make it. And that's an interesting argument. You've got basically this potentially $1 trillion company that the United States government may own 50% of because it's going to allow it to operate in the United States.
Yeah.
Is that a good thing or not? I don't know. I'm not really comfortable with that. I'm much more comfortable with Oracle coming in and saying, we're going to take TikTok and we're going to move it into our US-based computers and we're going to manage the algorithms. I can trust that. To say that we're going to take this and turn this big engine over to the same organization that runs the CIA, the NSA, the FBI, and everything, and it's going to be okay, I don't know. That doesn't give me a level of comfort.
Well, look, there's a lot that's going on right now with websites being shut down, with certain information being purged that, raises a lot of questions, but that's a whole other issue. So, of course, if there's a buyer, that all is said and done. General Atlantic CEO Bill Ford said it's in everybody's best interest. He's on the board of directors for the Chinese parent company, and he told Axios, we'll get on with it in terms of negotiating what might work. And the Chinese government, the U.S. government, and the company and the board all have to be involved in this conversation. You think ByteDance in the end will sell? Because that's another big question.
I think so. I think the argument that this trillion-dollar enterprise is worth zero if they don't sell is powerful incentive to cause them to sell. And the question is, who do they sell to? Possibly the owner of Twitter, Elon Musk, possibly Oracle, possibly Facebook. I don't know. But to me, I think that the fact they've got 90 days means they're probably going to sell to somebody.
Well, if it goes to Elon Musk, you've got to ask a ton of other questions.
No, it'll be like Twitter, right? So it'll be Twitter plus TikTok.
Well, if it goes to Elon Musk, you also have to ask, look, he invested $290 million in the Trump campaign. He's got too much control right now. But again, that's a whole other issue. That's a whole other show. Let's move on to another issue here on politics and power that may wind up before the Supreme Court. On day one, the president issued a patently unconstitutional executive order. That is not arguable. The goal to abolish birthright citizenship to children of millions of immigrants in the United States. Birthright citizenship is a fundamental right at the heart of the constitutional order. It is rooted in the 14th Amendment, enshrined in well over a century of precedent and practice. Fundamental question is, will the justices uphold birthright citizenship? Legal analysts say they should, and they cite three main reasons. One, legal, the fact that it's part of the Constitution. One, practical, and another related to the court's own power. Legal being constitutional, there, we decided that. What would the practical be?
Well, the practical effects would be, first of all, this executive order takes effect on February 20th. So anybody who came into the country before February 20th will not be affected. But if you come into the country after February 20th and you're not here lawfully, the executive order says that your children, therefore, do not automatically become citizens based upon birth. Now, if it's a U.S. citizen father and an unlawful immigrant mother, then of course the child does become a U.S. citizen. But you have to prove who the father is. If neither one, you can't prove who the father is. And by the way, the burden of proof is on the person seeking citizenship. And you don't know who the father is, and the mother was an unlawful alien, then, for instance, the State Department is going to deny you a passport. You're not going to be able to vote in elections, for example. You may be limited in the types of health care, medical care, education, and things like that you can obtain from the United States government. So those are the practical effects. There are about 5 million people who are currently in that category of being born in the U.S. to an unlawful immigrant. And they will not be affected. They'll be treated under the former law. What is the practical effect? You have to understand that birthright citizenship is the anomaly throughout the world. France, England, many European countries, New Zealand, Australia, none of these countries have birthright citizenship. U.S. Congress has submitted laws since 1991 doing away with birthright citizenship. So it's not a question that has it's not a universal principle. Now, is it a principle in the U.S. Constitution? Now, if you talk to the recognized academic scholars, of course, from Yale and Harvard, they're with you. This is blatantly unconstitutional. Lawrence Tribe even said that SOB is trying to change the change the outcome of the effing Civil War all by himself. There's a lot of strong positions out there on one side. So what is the court going to hear, though? It really is going to hear the other side. And the other side is, and there have been technological changes since we passed the 14th Amendment in 1867. There have been airplanes, there's vote by mail. The world has changed. And you know, when you in 1867, when this was passed, it was not passed thinking of immigrants. It was passed because of slaves. The Dred Scott decision came and said, persons of African descent who live here in the United States cannot become citizens. And therefore, they're not entitled to either state or federal citizenship. Dred Scott was a slave taken to Wisconsin by his owner. The owner passed away. The wife refused to grant him his freedom, and he went and filed a lawsuit, and the Supreme Court said, you can't bring a lawsuit, you are not a citizen, and therefore no person of African descent is a citizen of the United States. The Michigan senator who filed this said, this bill is only to deal with slaves. It doesn't mean that a Chinese person that moves into California becomes a U.S. citizen. It doesn't mean that a German person moving into Pennsylvania becomes a citizen. It only applies to slaves. So that was the original understanding. Then we get to 1902, and a Chinese man named Cho Wick, I think was his name, had been born in the United States. His parents lived in the United States before his birth, born in the United States, lived here for 24 years, started a business, and then went back to China to visit family, tried to come back in the country. They said, no, you're not a citizen, regardless of the fact that you were born here. So the Supreme Court in that court said, no, residency is what's important for citizenship. You have been a resident your entire life. Your parents are residents and are still residents, and therefore you are a citizen by virtue of being born in the United States and being a resident of the United States. So the question comes down to 6 words in the Constitution. The 6 words are, and subject to the jurisdiction thereof. Now, we all know there are certain agreements on that term. If you're a foreign dignitary here on a diplomatic mission and you have a child, your child is not subject to the jurisdiction of the United States and therefore does not become a citizen. So the court is going to have to struggle with those 6 words. If you are here unlawfully, are you subject to the jurisdiction of the United States? Those advocates for birthright citizenship says it's the soil that matters. If you're born on the soil, you're an American citizen. The advocates of doing away with birthright citizenship says, no, it's legal residency. If you're here legally as a resident, you're allowed to stay. What about birth tourism? You know, Joe Biden shut down birth tourism. We used to have airplanes that would fly into the United States with women who were 26 weeks pregnant. They go to the hospital. They'd obtain the childbirth at the cost of the U.S. taxpayer because they couldn't afford it. They would leave and never come back and claim that their child was a citizen. They'd seek a U.S. passport. Well, is that how we all think birthright citizenship work? If there are 100,000 Chinese who come into the United States, are born here and go back, does that mean we need to send 100,000 absentee ballots to them when the elections come? Does that mean that if a war starts with China, we can call those 100,000 and say, hey, you're drafted, you're going to serve in our military. You got to pay our taxes. Where's your tax return? We're going to tax you based upon your international income. So there are benefits and the burdens that come with birthright citizenship. What do I think the Supreme Court will do? I think the Supreme Court will grant a more restrictive interpretation of birthright citizenship, although it may say that the president can't do it by executive order. Maybe this is something that's relegated strictly to Congress. But I think that a restriction of some type on birthright citizenship is going to come.
So it's going to be subject to interpretation.
Oh, yeah, of course. That's what the Supreme Court's there to do. Determine what those 6 words, subject to the jurisdiction thereof, means. And we'll find out.
So, when politics and power continues, there are other things before the court. A look at the moment of threat doctrine. The court literally addressing how much time can be taken into consideration when police kill someone and holding police accountable for using excessive force. Politics and Power will be back right after this. Welcome back to Politics and Power. Bruce Hamilton with constitutional law expert Rod Sullivan. So the nation's high court also considering a case it's dubbed the moment of threat doctrine. It addresses how much time can be taken into consideration when police kill someone. Case stems from what was described as a routine traffic stop, though there is really no such thing, on a Texas highway that escalated into a fatal shooting. It left a 24-year-old driver bleeding to death while still in the driver's seat. What happened during those seconds and the minutes prior to the April 2016 incident is now central to a Supreme Court case. And Rod, the High Court's decision in this case could make it easier or harder to hold police officers accountable for the use of excessive force.
Yeah. This is an interesting case because the guy in Houston was a toll violator. He wasn't, fleeing from a felony or a murder or something like that. He was pulled over for being a repeat toll violator. So the policeman pulled him over. They asked for license registration. He says, well, I don't have the license and I don't have the registration. It might be in the trunk. After, a few minutes passed by and he wasn't able to produce any of this documentation, the police officer said, don't start the car, don't move, don't do anything. And the guy did. He started the car up and he started to pull forward. And the police officer stepped on the door jamb and the guy pulled away. And he pulled out his gun, shot him 3 times. First shot killed him.
Didn't follow police orders.
I'm sorry?
Did not follow police orders.
No, he didn't follow police orders, but by the same token, there was no indication at that time that he was a violent felon that would be a threat to other people on the road, except for the police officer who was standing on the door jamb. So the majority opinion throughout the United States is that you take the totality of the circumstances in deciding whether it was a justified shooting. And the rule in the Fifth Circuit, where Houston sits, is that you look at the moment of threat. Did the police officer during that 2-second period when the car was moving and he was standing on the door jamb have a reasonable belief that he was subject to death or serious personal injury? And the court found that he did. If you're on a moving car, it's pulling away, you can get run over by the car. Therefore, you do have a reasonable belief that you might be seriously injured. What do I think the Supreme Court's going to do? I think they're going to come down with the totality of the circumstances case. I think they're going to look at it and say, look, if this guy was no indication that he was going to hurt anybody else, we need to look at that, whether or not the shooting was reasonable based upon that totality of the circumstances. Is it going to change the outcome of this case? I don't know. I mean, certainly, if you have a circumstance where the guy doesn't appear to be a threat and all of a sudden he pulls a gun, do we have to judge that based upon the totality of the circumstances, or he's acting in self-defense at that point? So I'm not sure that it's going to affect the outcome of this case, but I think we're going to have a uniform rule throughout the United States that courts are going to look at the totality, not just simply at the 2 seconds, a moment before the shooting.
But the police argument would be this is a mitigating circumstance as far as they're concerned?
Yeah, I mean, the police are going to say, look, we're entitled to protect our lives like anybody else. There's nothing that inherently violating your civil rights by simply stepping on the door jamb, so that this particular police officer had a reasonable belief that he was going to be killed or seriously injured, and therefore shooting it was justified. A 12-person grand jury decided that the shooting was justified based upon the moment of threat ruling, and whether they'll do differently under totality of the circumstances, I don't know.
All right, time will tell. Get back to another First Amendment case before the court. This one is the Free Speech Coalition versus Paxton. It's a lawsuit challenging a Texas law requiring websites to verify the ages of people seeking adult content, like pornography. Free speech advocates and members of the adult entertainment industry sued to block the law and are being represented by the ACLU. The question the court must answer on this case is, this is what I told you to remember, this verbiage here. Does strict scrutiny apply? It's an important but tricky question. Everybody agrees that children should be protected from materials that can prove harmful to them. Okay, no disagreement there. But concerns linger that the rights of adults are being infringed upon to access materials, rights that are protected by the Constitution.
Yeah, I think people don't really understand this thing about pornography and the Constitution. Erotica is protected speech under the First Amendment. And the argument is that Pornhub and other online video sites, OnlyFans and things like that, is erotica, but it's not pornography. It's not obscene. And the line between what is obscene and what is erotica is very, very difficult to draw. But if we're assuming that everything that Texas is talking about falls in the category of protected erotica, then you have to apply that question of content-based and whether or not strict scrutiny applies. And then this comes down to the question of whether or not the remedy is narrowly tailored to the harm trying to be prevented. What Texas wanted to happen is for all of these sites to employ a third party to require people to upload identification of some type if their ISP came from within Texas and prove that they were over the age of 18. And after they did that, this third party was supposed to destroy the evidence, never let anybody know who it was who was accessing the sites. And then, you know, once somebody had been, ISP had been approved, then people could download erotica over the internet. Is this a narrowly tailored remedy? I don't really know a better alternative. You know, I don't know another way to prevent minors from seeing pornography. And the other question is it an effective alternative? Because you can use a virtual private network that shows that your
VPN.
ISP is anyplace else. Yeah, VPN. A lot of people recommend VPNs for private security. And if you have a VPN, it'll show that you're either in Los Angeles or New York or Chicago or someplace else. So it's very hard to actually make this an effective remedy. So will it slow down children using or accessing pornography over the web? I don't know. 14, 15, 16-year-olds, pretty savvy when it comes to technology.
They're very savvy, and they're very savvy about hiding things, too.
Yeah, very savvy. And they're probably more savvy than most Supreme Court justices about how to do this. So the Supreme Court could find that this is an ineffective, narrowly tailored remedy. So from the oral argument, it's very difficult to me to tell how this case is going to come out.
Right. So again, you know, the justices are being asked to decide whether the Texas law should be subject to the highest standard of judicial review, which is strict scrutiny. So again, for everybody, let's explain what strict scrutiny is.
Narrowly tailored to satisfy a compelling governmental interest. And compelling is the important word here. Because if it's just an important interest, but it's not compelling, then it's intermediate scrutiny, which is a lesser standard. And so consequently, you have to show that there's something very compelling about preventing teens, minors from downloading internet pornography and erotica. And I assume from the argument that the court is accepting the argument that this is a compelling governmental interest. Preventing minors from accessing pornography is compelling. I think they're going to come down on the question of how narrowly tailored is this? Is this a good remedy, a means to accomplish this objective? And I just really can't tell from the argument, you know, how they're going to come down. Nobody came forward and said, Coalition for Free Speech didn't say this is no good, but this would be okay. You know, they didn't want to give any room to those, Paxton and those arguing that this was okay, to come up with another alternative. They just simply wanted to say, we don't have to screen anybody. If you can get on the internet, you can look at our content, and that's all there is to it. So it's such a thorny question. Here's the question I think you can also look at is the Supreme Court going to second guess the state legislature in the state of Texas on this issue? Because it struggled with this issue. I think Florida has struggled with it. There are 18 states that are doing various types of identification of people downloading erotica. And they may say, look, this is a political question. The state legislatures are the best to handle it. You know, let me give you an example of what happened in the past. Now, people have not heard this, and they're going to roll their eyes and say, this can't be true. But in the 1960s, the Supreme Court used to screen pornographic films in the Supreme Court building. They had a theater downstairs, and the Supreme Court historian will deny this, but justices have written about it. And they would go down and they'd say, we're going to determine whether or not this film is obscene or erotica. And the famous Potter Stewart standard that said, I don't know what the definition of obscene is, but I know it when I see it. And the second part of that quote, which never gets added on, is, and this is not obscene. This is not obscenity. So they were actually looking at films. Well, finally they decided, look, we can't be doing this. This is not our job. It's a little seedy, it's a little tawdry, we're going to stop it. And the Supreme Court has sort of kept their hands off this obscenity pornography distinction since then because it's too hard. It's too hard for a non-political branch of government, allegedly non-political, to determine what is obscene, what is pornography, erotica, and what should be accessed by people in the United States. I don't know how they handle it. It's a very hard question. It's probably the hardest question they'll have to deal with this time. Maybe not the most important, but probably the hardest.
So you don't think they come down on the side of constitutionally protected access? They may just throw it back to the states?
I think they come down on the side of strict scrutiny, yes. But the question, deciding what is a narrowly tailored remedy, I think they might toss that to the states.
All right. Thanks again for being here on Politics and Power. Appreciate
My pleasure.
you. Other cases coming before the Supreme Court, and some decisions to be handed down. So you'll be back, right?
I hope.
Always appreciate you.
My pleasure.
Appreciate your time, your context, your perspective. Always love hearing from you, too. You know how to find us here at Channel 4. All you have to do is email us. And we've got another edition of Politics and Power coming up next week. In the meantime, you can review this show anytime on demand on the News4Jax YouTube channel and news4jax.com. As always, we appreciate you. Have a great day.
See why every day more people are choosing News4Jax, Northeast Florida and South Georgia's #1 source for local news.